I would like to add that during the proceedings before the pre-trial chamber, the President, in regard to the issue of detention, had invited a number of non-governmental organizations to file amicus curiae briefs. 6 amicus curiae briefs were filed. You will find them in the case file. If I remember correctly, 4 of the 6 non-governmental organizations supported the defense position. According to the law, due to justice and following the image and example that these extraordinary chambers should offer to all justice systems in the world, including the Cambodian justice system. How can NGOs come to support us before national courts if the extraordinary chambers themselves were to agree to irregular detention? So we ask you to take a difficult decision. We admit it is difficult, but it is the only possible one to take. We come before you to request that you put an end to the detention of Duch, because it is well beyond the acceptable time limits set by Cambodian law. And we have also exceeded the time limits provided for in international legal instruments. We referred to Articles 9 and 14 of the New York Covenant on Civil and Political Rights, and we recalled that in accordance with these articles, it is not possible to extend provisional detention for so long. Permit me to shed light using jurisprudence on the Articles 9 and 14 of the Covenant on Civil and Political Rights. I shall refer first to the jurisprudence of the European Court of Human Rights, that is Article 5 of the European Human Rights Convention, which on several occasions has found that countries, including mine, I must add, and very often Italy, has found them guilty of unduly extending provisional detention. And this provisional detention that I referred to has nothing in common with what Duch has suffered. We are approaching 10 years of provisional detention. Can this be imagined? And it is of particular interest, in my view, that I bring to the attention of the court the jurisprudence of the United Nations Human Rights Commission, or more precisely, the Working Group on Provisional Detention of the United Nations in this regard. On the 30th of November 2007, it issued, that is this group, an opinion on deprivation of liberty for 8 persons arrested in Lebanon following the assassination of the former Lebanese Prime Minister Rafik Hariri on the 14th of February 2005. You might find it worth knowing that the Special Tribunal for Lebanon, jointly established by the government of Lebanon and the United Nations, as it begins to do its work, this tribunal is facing the same problem that we have before you here today. The International Commission of Inquiry had recommended the detention of these 8 people to the Lebanese investigating judges, and the Lebanese investigating judges did in fact decide to place these 8 persons in detention. The Working Group on Provisional Detention, that is the United Nations Working Group, issued an opinion which indicated that it was not possible to continue keeping these people in detention and characterized the detention as arbitrary. As the Special Tribunal for Lebanon begins its proceedings, this matter will be brought before it, and it will have to render a decision in the near future on this issue with regard to 4 of these people, as the remaining 4 were released by the Lebanese investigating judges. So what are you going to do, Your Honors? We have passed out. We have shared the decision which was rendered in our case by the military investigating judge on the 21st of July 2008. We requested this decision because we asked the military judge what his position was in regard to the Duch case file, that is Duch, who had been brought before him. And the military investigating judge said, considering that the prosecution of the case of Mr. Kaing Guek Eav, alias Duch, of the military tribunal, because at the time there was no law on the establishment of the ECCC, considering, I beg your pardon, Mr. Petit interrupts. Mr. Hu, I thought it had already been done. I'm sorry.
Vous avez version Khmer et version française.
You have the Khmer and the French version. Mr. Hu continues. Considering that after the establishment of the ECCC, the jurisdiction of the ECCC covers crimes against humanity and grave violations of the Geneva Convention of 12 August 1949, committed during the period from 17th of April 1975 to the 6th of January 1979. The military tribunal no longer has jurisdiction over crimes falling within the jurisdiction of the ECCC. Considering that the charged person, Mr. Kaing Guek Eav, alias Duch, has been prosecuted or is being prosecuted by the ECCC with effect from the 30th of July 2007, decide to put to an end or to bring to an end the jurisdiction of the military tribunal with regard to case number 397 of the 6th of March 1999, under which the charged person, Kaing Guek Eav, alias Duch, was questioned with regard to crimes provided for in the law establishing the ECCC. Phnom Penh, 21st of July 2008, the investigating judge. Following this decision of the military judge, which notes that he has lost jurisdiction in favor of the chambers, you are the continuation of the proceedings instituted against Duch, and this is clearly indicated in the first paragraph of this decision. Previously, the case fell within the jurisdiction of the military court because there was no law on the establishment of the ECCC. So there is a thread of continuity running through the case. You can no longer say, this is not our problem. I am sorry to bring this before you. It is now your problem, and you cannot avoid it. So what do we do now? First, I think we should rely on jurisprudence. And in this regard, I can think of no better jurisprudence or precedent than what transpired in the Barayaguiza, and I apologize to the interpreters, says Mr. Hu, which I shall spell, which is Barayaguiza. Barayaguiza Jean Bosco. So, what was the issue at stake? The defense submitted that Mr. Barayaguiza, of whom it was commonly said that he was one of the main perpetrators or persons responsible for the Rwandan genocide, that his rights were violated or breached during his arrest, and he was kept in detention in violation of these rights. I now turn to paragraph 106 of the judgment of the 3rd of November 1999 by the Appeals Chamber of the International Criminal Tribunal for Rwanda and the former Yugoslavia, in which the appeals chamber said, the crimes charged against the accused are very serious. This notwithstanding, in the case in point, his fundamental rights have been violated on several occasions. There was a small paragraph for the prosecutor which is not relevant to the prosecutor here, but the chamber in the Barayaguiza said, and this is undoubtedly worse, the following: it would seem that the actions or the failure to act on the part of the prosecutor in that case amounts to negligence. But of course, this would not be true for our co-prosecutors in this instance. And in order to come to this determination, the appeals chamber of the ICTR concluded with the two paragraphs that I shall read out to you. In the instant case, we appreciate the power of words spoken by Judge Brandeis of the United States Supreme Court. We quote, "Decency, security, and freedom require that representatives of the state are subject to the same rules of conduct as ordinary citizens. In a state where the rule of law prevails, the existence of the state is jeopardized if the state itself fails scrupulously to comply with the provisions of the law. The state is the powerful and omnipotent institutor of force for good or evil. It teaches the people by example. Criminal conduct is contagious. A state that breaks the law encourages contempt for the law. It therefore invites each citizen to make his or her own law and encourages anarchy. To say that for the administration of criminal justice, the end justifies the means, criminal would lead to a terrible boomerang effect. As Judge Brandeis said, the court must take a firm stand against this pernicious theory. End of quote. And having quoted Judge Brandeis, the chamber ended its judgment. Thus, the court, and here we make reference to the International Criminal Tribunal for Rwanda, is an institution whose primary goal is to ensure that justice should be done, should not endorse such violations, and I refer to the violations I mentioned earlier. That is, it should allow that the appellant should be tried on the basis of charges of which he was accused too late would be a travesty of justice. Nothing less than the integrity of the tribunal is at stake. If the public were to lose confidence in this tribunal as the custodian of the human rights of every individual, including those accused of unimaginable crimes, would be one of the most adverse consequences, and it would be wrong to allow the accused, the appellants, to be tried in spite of such breaches. Although it is difficult for some to accept such a finding, it is the role of an independent justice system to end these proceedings so that other injustices may not arise. Mr. President, Your Honors, this decision or this judgment honors the international justice system. I can imagine in what state of mind the judges who rendered this decision might have been. They were presided over by Judge Gabriel Kirk MacDonald. I can only imagine. The chamber had gone very far because it ordered the immediate cessation of proceedings, and it prohibited the prosecutor from resuming the proceedings. I can assure you that we have not yet come to that. And I must be exhaustive, and I should add, therefore, that in the wake of this decision, the prosecutor, Ms. Carla Del Ponte, who had just been appointed international prosecutor, applied for a review of this judgment, and in a famous statement during a hearing, she said to the appeals chamber judges, if you were to uphold this decision, we can stop the proceedings. It was not a very legal thing to say, but it is true that the appeals chamber did review the decision, and the second decision it took was interesting too. And the appeals chamber said, yes, there was a breach of the rights of the accused. That is true. But we cannot ask that proceedings be brought to an end. However, we do say that after these proceedings, if the accused were to be found guilty, there would be a reduction of the sentence. And that is what happened. Mr. Baraya Guiza was found guilty. He was sentenced to life imprisonment, I believe, and his sentence was reduced to 35 years to take account of the breach or violation of his rights. So what do we ask of you today? Primarily, to bring immediately to an end the detention of Duch for the duration of the trial. And I emphasize, for the duration of the trial. And so, following on from what Mr. Kasavut said yesterday, we would re-establish the balance for the duration of the proceedings between what the co-prosecutors now refuse to prosecute, for those that the co-prosecutors refuse to prosecute for even more serious crimes, and Duch on the other side. These people are free today. Their names are mentioned in the press. They are not prosecuted. So be it. So that it would not be out of the question, therefore, for your chamber to say, well, for the duration of the proceedings at least, whatever the charges for unimaginable crimes pending, we should free Duch for the duration of the trial. The defense would not challenge. The defense would not challenge the conditionalities imposed on this release. Why not decide, for instance, that Duch would be in a safe house, as has been allowed in other courts? And in this regard, Mr. President, Your Honors, permit me to make a common sense observation. Duch is a co-detainee with people who will be mentioned in the course of these proceedings. Do you not think that it would be preferable for all concerned if he were not detained at the same time as these people? So let us face facts. Let us be pragmatic. Let us apply the law. But let us allow what Duch has said, or let us allow Duch to be free to speak in the course of the proceedings. So, release, yes, but with conditions that you will decide, and justice will have been done.
Tout à fait subsidiairement.
As a side point, if you believe that for such and such a reason,
Le mettre en liberté.
The defense is requesting from you to say as of now two things. On the one hand, that in the case of sentencing, that the time spent in detention since May 1999 should be taken into account and subtracted from the sentence. And on the other hand, that he will be entitled to a reduction of the sentence to compensate for the violation of his rights, and going and restating the second decision of the appeal chamber in the Baraya Guiza case. This is, I believe, with the totality of these possibilities, the solutions that are presented to you, in order to settle on this difficult issue. May I please say a last word to the civil parties? Nothing has been done against your rights. Everything is done for law. And I can imagine very easily that even as civil parties, you will only be able to second this position. I consider that the civil parties can only intervene in a hearing about detention if and only if they can provide the evidence that the release would damage their rights. The rest does not concern them. I cannot imagine one single moment, on one hand, that the release of Duch in a safe house would hinder the rights of the civil, be detrimental to the rights of the civil parties. I cannot imagine that, whereas we are here to seek law, that anyone can oppose himself to the application above all of law. Law, Cambodian law, that states that any person can not be maintained in detention for more than 3 years. International law that prohibits arbitrary detention. Thank you.
The President, the trial chamber would ask the co-prosecutors if they wish to respond through the defense counsels regarding his presentation and the reasons concerning that issue, the issue of the detention of the accused, and other issues which have been raised by Francois Roux. If you have, please comment. Thank you.